Getting engaged is, easily one of the most exciting milestones in a couple's life. You're picking out venues, tasting cakes, drafting those endless guest lists. The months leading up to a wedding are literally just filled with joyful planning. But right in the middle of all that excitement, there is one absolutely crucial conversation that so many couples avoid until the literal 11th hour. Yep, the prenuptial agreement. Welcome to this explainer. Today, we are going to completely rethink the prenup. We'll look at how planning, disclosure, and enforceability can actually strengthen your relationship instead of putting a strain on it.
But hey, before we really get into the weeds, a super quick note. This explainer is actually brought to you by our sponsor, the law offices of Norka M. Schell, LLC. They're dedicated to helping couples navigate these exact conversations, helping you build a rock-solid foundation for your shared future. Oh, and a quick disclaimer for you, the information we're chatting about today is just for informational purposes, so it does not constitute legal advice. All right, let's get into it.
Okay, let's dive into this. When do you think the right time to talk about a prenup actually is? Seriously, think about it. Is it right after you get engaged? Maybe a month before the big day? Or is it before that ring is even bought? Look, we usually associate this topic with, a ton of awkwardness. But as you'll see from our sources, timing isn't just about avoiding a stressful conversation over dinner. It actually has massive legal implications for whether your agreement holds any water at all.
Section 1. Rethinking the Prenuptial Agreement.
We really need to pivot away from this whole stigma that prenups are, inherently unromantic. This brings us right to the elephant in the room, the big fear that completely stops couples from having this chat during peak engagement season. Does a prenup mean inevitable divorce? So many people mistakenly think that just asking for one means you're already anticipating a split, or that you're kind of betting against your own marriage. It can feel like a self-fulfilling prophecy, right? But we absolutely have to flip that narrative. Because the myth is that prenups mean you expect to get a divorce. But the reality? Prenups are actually a roadmap for your financial future. Think about it the way attorney Jennifer Brands explains it. She says you should treat a prenuptial agreement just like an insurance policy. I mean, you don't buy car insurance because you're planning to crash your car tomorrow, do you? No way. You buy it for mutual protection, security, and just overall clarity. It ensures that both of you feel financially secure no matter what crazy curveballs life decides to throw your way.
Section 2. Why early planning matters.
Let's move to and see how this builds, because timing and pacing are literally the first major legal pillars of a prenup. Let's look at what an ideal timeline actually looks like. First, up to a year before the wedding, often before the question is even popped. That is the golden time to start discussing finances. It builds so much trust and aligns your long-term goals. Next, months before the wedding, you actually draft and negotiate the terms with your own attorneys. And finally, the days before the wedding, guys, that is the legal danger zone. Waiting until after the proposal, or worse, right before you walk down the aisle, introduces massive tension and puts the legal integrity of the entire agreement at serious risk. As our sponsor, the law offices of Norka M. Schell, LLC perfectly sums up. Starting early protects the legal integrity of your agreement and completely removes that intense wedding countdown pressure. Because drafting a legally sound, totally fair, and comprehensive agreement, it takes time. If you start this whole process just a month out, you are adding immense stress to a time that's already, quite frankly, stressful enough. Rushing it can lead to devastating legal vulnerabilities that could honestly render the whole document completely useless years down the line. Section 3. The power of financial disclosure. So the crucial point is, you absolutely cannot have a fair agreement if you don't actually know what you're agreeing to. Both parties have to bring a full disclosure checklist to the table, and we're talking everything here. This includes all premarital assets like real estate or your savings accounts, but it also absolutely includes debts. Say one partner has significant student loans or a bunch of credit card debt, a prenup can explicitly ensure the other partner won't be on the hook for it. You also have to lay out potential inheritances, trusts, and any business interests. Creating this level of financial intimacy before you say "I do" ensures there are absolutely no nasty surprises later on. And this brilliantly illustrates how full financial disclosure actually transforms money from this awkward, taboo topic into a shared team strategy. Nurturing a shared financial future really requires deep honesty. By having these tough conversations early on, talking about your spending habits, your retirement goals, your current financial realities, you're actually building a much stronger foundation of mutual respect and problem solving. You're tackling it together.
Section 4. Ensuring legal enforceability.
But here's the thing. Even if you have the greatest, most productive conversation ever, the document still needs to actually hold up in court. Many states, like Washington, for example, use a really strict two-pronged test to evaluate if an agreement is fair.
Step 1 is procedural integrity. Basically, the court looks at exactly how the agreement came together. Was it voluntary? Did both of you have access to your own lawyers? Was there enough time? Then step 2 is substantive fairness. This looks at whether the actual economic outcome of the agreement is reasonable, making sure it doesn't just completely take advantage of one partner. Let's zoom in on procedural integrity for a second by defining duress and coercion. In the prenup world, this essentially means putting unfair pressure on someone to sign the contract. And guess what the #1 diagnostic tool courts use to prove coercion is? Yep, timing. Presenting this massive, complex legal agreement to your partner the night before a wedding, or, threatening to cancel the whole event if they don't sign right that second, that practically screams coercion to a judge. Now, what's really interesting about this slide is how courts actually apply this timing rule in real life. We've got 2 real cases from New York to compare here. In the first case, an agreement was totally invalidated because it was presented a mere 2 weeks before this huge, elaborately planned wedding. The court essentially said that this late presentation, among some other factors, completely destroyed the agreement's validity. But then, contrast that with a second case. Here, an agreement was actually upheld, even though it was physically signed literally the night before the rehearsal dinner. Why? Because the couple had been actively negotiating it for 4 whole weeks, going back and forth through 6 different drafts, with input from both of their lawyers. The timeline of the negotiation itself made all the difference in whether it was enforceable.
Section 5. Building a financial partnership.
So we've covered the planning, the deep dive disclosures, and the strict legal rules of enforceability. At the end of the day, drafting a prenup isn't about preparing for the absolute worst. It's just really smart, mature life planning. It's an act of love, transparency, and partnership. Remember, every single state has default laws that dictate exactly how property gets divided or how support is awarded if a marriage ends. If you do nothing, you are basically just accepting the state's generic prenup. So the ultimate question is, will you just settle for the state's default laws, or will you take control, sit down with your partner, and proactively write your own rules? Rules that actually reflect your unique relationship, your shared values, and your mutual respect. The choice is totally yours. Thank you so much for joining me for this explainer, and I really hope it empowered you to start these vital conversations sooner rather than later.